Okay, we are on the record. It's the people of the state of Michigan versus Brandon Juwan Baker, 2356477. Mr. Baker is charged with count 1, police officer assaulting, resisting, and obstructing. Count 2, which is a misdemeanor trespass, set for a probable cause conference today. Appearances.
Edwin Milwaukee, C54828, appearing on behalf of the people.
And good morning, Your Honor. Good morning to your staff. Neighborhood Defender Services by Ken Riggins, P82125, on behalf of Mr. Brandon Baker, who appears via Zoom.
Mr. Baker, can you please, he doesn't have audio.
Your Honor, if he doesn't have audio, I can waive his presence. I spoke with him both this morning. I went to see him in the jail yesterday.
Okay, he is logged in. I will waive his presence for today's hearing. Do you have discovery?
Yeah, I believe I received an email. I looked before I left for court this morning. I believe there was an email from Danielle Petrick for discovery. There's another issue in this case. Mr. Baker has a case that is in front of Judge Giles.
It's being transferred to Giles.
I'm sorry?
This is being transferred to Giles after today.
Okay. All right, but I'm sorry.
I didn't mean to cut you off. You never stated what your issue was. I'm sorry.
My issue was the fact that there was another case in front of Giles, so you addressed it, so I think we're good with that.
Okay, so they gave a date of May 4th at 10 a.m.
Can I take a look at my schedule?
Yeah, but they're gonna talk to Clerk and Giles because their dates are pretty set.
Yeah, I'm aware. So May 4th at 10 a.m. I will assume it's good, and if not, I'll contact Judge Giles' courtroom.
Okay, anything else?
Nothing further, Your Honor.
All right, have a good rest of your day.
Thank
Mr.
you.
Baker. Mr. Baker has audio now. Mr. Baker, unmute your device. You have to unmute your device. I can't hear you.
Good morning.
Good morning. So, Mr. Baker, all we just did, you didn't have audio, we just did date for you. And your case is being transferred to Judge Giles since you have a pending case with him already, okay?
Okay.
So this case is May 4th at 10 a.m. in person at 36th District Court.
So not today?
No.
Well,
May 4th.
Today was basically to discuss any preliminary matters.
May 4th. Okay, I'm gonna write it. I'm gonna take note.
10 a.m.
Okay. Give me a call in a little while. I'm on going to court. Give me a call and I'll discuss it with you. All right.
Okay, and you a specific time or?
No, 2 hours.
Okay,
I got a hearing. Okay.
Perfect. I really appreciate you.
All right. I'll talk to you, Mr. Baker.
Okay.
Okay.
All right. Goodbye. Okay, we're on the record. This is the people of the state of Michigan versus Kenneth Bragg, 2356308. Mr. Bragg is charged with 1 count of police officer fleeing, 4th degree vehicle code, an habitual offender second offense notice set for a preliminary examination today. Appearances.
Edwin Milwaukee, P54828, appearing on behalf of the people.
Good morning, as always, to you and your staff, Judge Cody Bradford with Neighborhood Defender Service P85944 on behalf of Mr. Kenneth Bragg.
Okay, I I don't see Mr. Bragg present.
He is not here. The number I have in the file, I've called multiple times. It rings once and goes straight to voicemail. I've sent a text message. Unfortunately, I've had no other information to give to the court about Mr. Bragg's whereabouts.
Okay, anything from the people?
We asked the, KBS,
I'll do 1,000 persons.
Thank you. If I do get in contact with him, could I potentially zoom in to have the warrant set aside?
Yes.
Okay, thank you.
Anything else for the record, either party?
No, not from people.
Nothing from the town.
Thank you. Thank you.
Okay, we are on the record. This is people of the state of Michigan versus Roger White, case 23056129901. His wife is charged with 1 count of assault with dangerous weapon, police assault, that for preliminary examination appearances.
Good morning, Your Honor. Daniela Parrish on behalf of the people, PA 5495.
Your Honor, may it please this honorable court, Larry Pope on behalf of Raja White, who stands directly behind me. Ms. White, would you state your name for the record, please?
Roger White, good morning. Are you ready to proceed?
Your Honor, my apologies. People are unable to proceed at this time as our complaining witness has failed to appear. Thank you for giving me a few moments. I was speaking with the OIC outside. Normally, as I explained to defense, the OIC, the people would ask for an adjournment after the OIC has brought to my attention that their unfamiliarity, can't speak this morning, with our new system. They didn't see the subpoena. That being said, however, I personally was at the office last night till 8 p.m. trying to reach the complainant, and I called multiple associates of the complainant and put them on notice, which they have called, and I called her mother. So to that, I would say that they knew, somebody knew, and they avoided responding to me. That also being said, the OIC confirmed that she attempted to call this morning, and we have not heard back. So at this time, people feel confident we have done all that we can to put them on notice about today's preliminary exam.
Okay, anything from the bench?
Judge, I just asked that it be dismissed. I've already told my client if in fact it's dismissed, it's without prejudice. If they can come forward, this case can be reissued.
I will dismiss without prejudice. We're not ready to proceed today. Mr. White, today's been dismissed, but you understand it could be reissued. You understand that? Attorney Polk and White, coach on an unrelated matter. Ms. Pilkowitz, good morning.
Morning, Judge. Sorry for the delay. I'm here on Anna Bailey.
Okay, Ms. Bailey's not here. Do you want to wait for her or call a case?
No, she's in the jail. I can waive her presence.
All right, we're on the record. This is the people of the state of Michigan versus Anna Bailey, 2162467. Ms. Bailey is charged with one count of controlled substance, delivery, manufacture, cocaine, heroin, or another narcotic less than 50 grams, set for a probable cause conference for the appearances. Oh, you know what? There's no prosecutor in the courtroom. Just give us a moment. In the meantime, Attorney Cookwood, I'm sending over some dates for an exam.
Thank you, Judge.
I didn't realize you weren't in here, sorry. Just put her appearance on, or actually she did. So whatever you're ready.
Okay, Edwin Sawaki, P 54828, appearing on behalf of the people.
Neighborhood Defender Service by Jackie Pilkowitz, P81653, on behalf of Miss Bailey, who is in custody in the Wayne County Jail. I'd ask that the court waive her presence for purposes of this proceeding.
I will waive her presence. Attorney Cookwood, do you have discovery?
I have paper discovery, Judge. I don't believe I have digital, so I'd be requesting that at this time.
Let me check here, Your Honor. Okay, at this time, we don't have the digital either. We're trying to find out what with the OIC, if there is digital. So that's where that's at.
And it's a MSP case, so I imagine at the very least there should be some dash camera footage, if not body cam. And also, I don't have a copy of any of the preliminary testing done on the alleged controlled substance case.
Yeah, it should be in the paper, yeah.
I see the court, I can sort it out with APA Sawaki if I'm missing anything. I see the court proposed a couple of dates. I'm just looking at my calendar now for an exam. Judge, I could do the 11th at 1:30.
Okay. And if for some reason the discovery issues are not resolved, the day before at least, could you zoom into the court?
Yes, I will.
Okay. Anything else?
Nothing for the people, Your Honor.
Nothing further, Judge.
All right, have a good day.
Thank you.
No. Sir, in the Wayne County Jail, can you state your name, please? The gentleman in the Wayne County Jail, Mr. Brown.
Once again,
Huh?
give me your name.
Jim Brown?
Okay, this is case 23056342201, people of the state of Michigan versus Jim Brown. Police officer assaulting, resisting, and obstructing, set for a tether violation hearing. Appearance?
Good morning, Your Honor. Danielle Parrish on behalf of the people, P85495.
And Mr. Brown, can you state your full name for the record?
Jim Brown.
Okay, Mr. Brown, normally I will have an attorney appointed to you for this matter, but I'm looking at the incident report here. They have you violating for 5 different times, but you were not in violation because your curfew was from 10 p.m. to 7 a.m. I'm not sure why they said you were violating. There's only one time on here you left at 6:12 a.m. and you are supposed to leave until 7 a.m. I don't have an issue with it, so I'm going to have you released back on tether.
So I'll be able to leave today?
You have to get a tether. I don't know how long that's gonna take, but you should not be in custody based on the report.
29/11, that's what Tyler Smith would do.
Any objection? The facts, my decision.
No objection.
Your Honor,
Yes,
Your Honor, I thought you said I thought you said I could be out from 6 a.m. to 10 p.m. Yeah, but.
I said 7 a.m., but that's fine. I mean, I can change it to 6 a.m. You're not a problem. You're not one of my people with issues. So I'll change it to 6 a.m. That's fine.
Yeah, but they arrested me while I was at work yesterday morning.
Yeah, I don't know why they have on here several different times that you were violating, but I didn't have a restriction for the time that you were out. So I'm not sure why they violated you.
That's crazy. That's
So,
really crazy.
Mr. Brown, listen up.
Yes, I'm listening.
So when you're released, if for some reason you have difficulties with your job, call the court and I will speak to your job that it was a mistake and that you were not supposed to be picked up, if that's an issue.
Yes, Your Honor.
Hey, that guy's Tyler Smith, right?
So I'll send over order right now to have you released.
All right, thank you.
I'll be there.
You're welcome. Have a good day. Two, 57418, the people of the state of Michigan versus Rashad King. Charged with 1 count of police officer assaulting, resisting, and obstructing, set for a preliminary examination of state appearances.
Edwin Milwaukee, P54828, appearing on behalf of people.
Veronica Walrad with the DS P85665, appearing on behalf of Emil Manley, who is charged in this case as Rashad King.
Okay, and sir, can you state your name for the record?
Emil Manley, Ron.
Have you also been, have you ever gone by the name Rashad King?
No, somebody, a family member of mine used my identity before they stole my identity.
I can.
I said a family member of mine stole my identity. They used his name allegedly to get traffic tickets in my name out there in Madison
The name
Heights.
is associated with it.
Yeah, they stole my identity.
Oh, rather, but it is now associated.
Yeah, it's associated with it.
Okay. Are the people ready to proceed?
No, Your Honor, we are missing a central witness.
Anything from the people from the fence?
Yes, Your Honor, we would move to dismiss as we are prepared to proceed.
Okay, I'll dismiss without prejudice. The time is now 9:43. See if we're not ready to move forward.
Thank you, Your Honor.
Well, it shouldn't take long for the dismissal.
Thank you so much.
Commissioner Chabelle, and Attorney Ryan, as soon as, Attorney Polk logs on, I can call the case.
Thank you.
Yes, thank you.
You're welcome.
Morning. All your instructions must be filed by
Okay, I'm ready on Mr.
November the 3rd.
Attorney Ryan, I just sent you a message on the chat. And it's just
Thank you. I see it.
Okay. We are on the record. This is case 2106064801, people of the state of Michigan versus Rufus Chappelle, charged with one count of embezzlement, $50,000, $99,999. Set for a motion, emergency motion for attorney withdrawal. Appearances, everyone.
Good morning, Your Honor. Assistant Attorney General Sean Ryan appearing on behalf of the people.
Is Attorney Polk, your device is muted. Can you unmute your device and put your appearance on?
I think he's frozen.
Mr. Chappelle, while we're waiting for Attorney Polk to log, to state his appearance or his name, please state your name, please.
Rufus Chappelle.
Thank you. What I could do, I did receive a motion in writing from Attorney Polk. I did have a chance to review it. There he is. Attorney Polk, can you put your appearance on, please?
May it please this honorable court, Larry Polk on behalf of Mr. Rufus Chappelle, who is present by way of Zoom, gives his permission and consent to have this hearing by Zoom. Mr. Chappelle, can you state your name for the record, please?
Rufus Chappelle.
Okay, it's your motion.
So Judge, this is my motion to withdraw as counsel. I've had discussion with Mr. Chappelle in reference to this particular case, our efforts to try to resolve it. I've spoken to the prosecutor, they have no objections. Spoken to Mr. Chappelle, he has no objections as well. And so based upon that, I do believe that there has been a breakdown in the attorney-client relationship, and I'm asking to be allowed to withdraw as retained counsel in this matter.
Okay, I find good cause based on the motion request and no objections from anyone. I do have Attorney Chambers present in person. He was here for an exam. He's the one that has been appointed to Mr. Chappelle to represent him. I have sent to Attorney Ryan, Attorney Chambers, email address. So I would say, Attorney Polk, you have been withdrawn. I will grant your request. So.
All right, thank you very much. And Attorney Chambers, you can feel free to give me a call and we can discuss anything I can do to assist Mr. Chappelle and you in this matter. I'm more than willing to do it. Mr. Chappelle has been a very cooperative client.
I appreciate that, Mr. Polk. I will do that.
Okay. Everyone.
Your Honor.
Yes.
If I may, would it be possible to set this instead for another exam for a date for a probable cause hearing? There's going to be a great deal of discovery, excuse me, for counsel to go through.
Let me make this date the BCC date.
If we could, yes, for the record, Attorney Chambers on behalf of Mr. Chappelle. That was my one concern, Judge. It is my understanding that the preliminary examination date was scheduled for May the 5th. I would be available at that date, but my one concern is the amount of discovery and having an opportunity and a good and fair opportunity to go over this evidence with my client and have discussed it with him. So with that assertion by counsel, I would ask that they be turned to the proper cause.
Okay, that's fine. We can keep it at 9 o'clock unless you all want to do 8:30.
Either one is, I defer to my client on that. Either one is good for me.
Can you repeat the dates and times, please?
May 5th, 8:30 or 9 o'clock.
9 o'clock would be fine.
Attorney Ryan, does that work for you?
It does, most certainly. I'm not sure what Mr. Chambers' schedule is. I'm gonna be honest, I don't know if that'd be enough time for him to review everything. But I'm happy to keep that date on. However,
It'll be probable cause conference, and then we'll
Okay.
schedule out. It'll be probably 2 weeks from then.
okay, thank you.
Please have an idea of what I'm doing.
Sure.
Okay, all right, I'll see everyone. It'll be on Zoom, Mr. Chappelle, May 5th at 9 a.m., okay?
Okay,
Thank you, George.
You're welcome.
Thank you very much.
Oh,
Because I need to, Mr. Chappelle, you have something to write with?
yes,
Take my phone number down, please, and give me a call or send me a text message.
I'll do that.
All right, 313-658-1338.
Okay, that's 313-658-1338.
Yes.
Okay. I'll send you my information now.
I appreciate it.
Thank you.
Everyone have a good day.
Thank you.
Thank you.
You're all set, Mr. Chappelle.
Thanks. Have a great day. Bye.
Thank you. Pass it right back to you. Anybody here on the phone?
Yeah, everybody here on. Good morning, Anna. Hey, bud.
Okay.
We can address it, we can address it. If you go, something.
Ready, I'm over. This is the walk.
Yeah.
Okay, we're on the record. This is people standing versus Joshua Gova. 2356027. Mr. Gova is charged with count 1, stolen property, receiving and concealing a motor vehicle. Count 2, police officer assaulting, resisting, and obstructing. Count 3, controlled substance possession. Analogs with the habitual offender 4th offense notice set for a preliminary examination today. Appearances.
Edwin Milwaukee, P5482A on behalf of the people.
And good morning, Your Honor, Arnie Chambers, on behalf of Mr. Gobas, stands to my right, ready to proceed.
Joshua Gova for the record.
Good morning to everybody. Are the people ready to proceed?
Yes, Your Honor.
Okay, any preliminary matters?
None from the people.
So you ask for sequestration of witnesses, Judge, I don't think it'll be an issue.
Okay, if there's anyone on YouTube or on Zoom who may be a potential witness on this case, now is your time to log off. For the record, in the courtroom, there are only attorneys, Mr. Gova, and staff present. So with that, you call your first witness.
Our first witness will be Trooper Jared Owens.
Make sure you speak up in the microphone so we can all hear you. Have you ready?
Sir, officer, could you state your name and occupation, please?
Jared Owens, Jerad Owens, Owens. I'm a trooper with Michigan State Police.
How long have you been with that agency?
7 years.
Were you on duty on March 20th, 2023?
I was.
And was that in the area on Rose Road?
Ross Road, yes,
And is that in the city of Detroit, County of Wayne?
that is.
What were you wearing that day?
My typical uniform that I'm wearing right now.
And what kind of type of vehicle were you in?
I was in a Michigan State Police patrol vehicle.
Fully marked, semi-marked?
It's fully marked, blue in color, has a red bubble on the top, it's pretty recognizable.
And while you, on that day and in that area, did you observe anything?
Yes.
And what was that?
I observed a white Durango, disregarded traffic control device and went to a red light.
And what did you do at that time?
At that time, I went to attempt to initiate a traffic stop and, the vehicle, I guess, would attempt to elude me and not want to stop. I mean,
And what continued to happen?
he drove around in circles on the service drive.
Judge, I would just object as to what the individual's intent.
Or
That's
when
speculation.
he attempted to elude,
Yeah.
any response?
No, Your Honor.
Okay, I will strike that part, attempt to elude based on speculation.
Please keep your testimony to what you observed.
Okay.
You know, as I understand, you were pursuing this vehicle?
Oh, I wasn't pursuing him, no, I just went to go stop him for the traffic, violation he committed.
And what happened after that?
He entered, the freeway, I entered the freeway behind him, I had my lights and sirens on, his vehicle was slowing down. At which point, I believe he was taking the exit to Cadieux. I went to follow him off the exit, and then he abruptly, turned back onto the freeway. I guess you could say crashed into the Gore area, which is
What area?
the Gore. It's going to be the area between the on-ramp and the freeway. That's what they call the Gore. His vehicle became disabled. At that point, his vehicle went up the embankment and he exited the vehicle and he ran away from the vehicle.
You have any, at that time before you crashed, or vehicles disabled, do you have any idea how fast it was going?
Not very fast, I'd say less than the freeway speeds, which obviously in Detroit is 5. So I'd say he was probably going maybe 45 and just slowing down.
And what did he run into exactly?
It's like the center median embankment. So like essentially like there's a curve, and I guess he just ran over that, and when he went trying to get back onto the freeway.
After the subject left the vehicle, what happened then?
Me and my partner both exited the vehicle. Obviously run after the suspect. I observed that there's a passenger in the vehicle, and then I ordered him out the vehicle, took him into custody.
And then, from your purview, what happened?
My partner continued to chase the driver up the main car up the off ramp.
At some point, did you join your partner?
Yes.
What happened then?
After I took the passenger into custody, I followed my partner up the direction of travel that he went up the off ramp. Saw that he was on the service drive, and he was on top of the driver, and that's my assistant taking him to custody.
Did you search and this is the person you took into custody in the courtroom today?
Yes.
Could you show us his location and identify a piece of clothing that he's wearing?
He's sitting right in front of me, and he's wearing a green jumpsuit.
Let the record reflect that the officer has identified the defendant.
So reflected.
Did you search the defendant?
I believe my partner and myself did search the defendant.
Both of you?
Yes.
Did you find him?
I did not know.
Did you observe your partner search the defendant?
I believe I did, yes.
Did you observe that he found anything?
I believe he said that he like a satchel.
Judge, I gotta object there. That's gonna call for hearsay and speculation. With the I believe and what he was about to say, I don't know.
Did you, was the vehicle involved? Drowning?
Yes.
And what did that show?
Obviously I ran the lane to, dispatch center. Flight did not come back to the vehicle, so at which point I ran the VIN number to the, vehicle, or dispatch center.
Did you search the car?
Yes.
Did you find any?
There were some, hydrocodones that were in the, center console. I created.
Did you find anything else that on it?
Nothing. I mean, I guess that was on its person. Was it on the key fob? It was a flat key fob, so it didn't match the vehicle. And obviously, due to my training experience, when individuals steal cars and they reprogram, they use key fobs that don't come back to the vehicle in shape.
Okay. Could you explain to the court a little bit more about how that works and shapes and whatnot?
Well, a shade key fob, but there's no, there's one of the vehicles you can't take the key and unlock the car.
So how do they unlock the car?
It's a reprogrammed key.
Good. I'd object to the question itself, but I would have to call for speculation.
In regards to how you unlock the car?
Yes,
Yeah.
and the answer should be strict as well, if it's not responsive to the question.
Simply because trooper, if he wasn't there to see the defendant unlock the car, he wouldn't know.
Okay. Did you interview the defendant?
Oh, yes.
Did you read him his memorandum?
Yes.
What, did you read him off of something or?
Yeah, I wrote them off with my memorandum warning start.
And did the defendant make a statement?
Yeah.
And what was that statement?
I don't recall word for word what he said, but he did make a statement.
I have nothing for. What is it? If I show you your report with that, refresh your memory.
Oh, yes.
Any other questions, John? Yes. What was that? Refresh your memory.
A little bit, yes.
Okay, you recall the defendant made a statement of any sort?
Yes.
What was that statement?
Just that the pills and the Suboxone strips that obviously were located after the fact were hits.
Can you say what you said? What type of strips?
The Suboxone strips.
How do you spell it? You know how to spell it?
Suboxone.
I'm sorry.
You said yes or no if you don't.
I have to refresh my memory, but I think it's SUBOXON, Boxon.
Thank you.
I have the spelling here. It's SBOXON. Okay. Do you give any indication of why he did not stop for you?
I believe he just freaked out that he saw a patrol car.
I have nothing further, Your Honor.
This key fob, was it taken into evidence?
I don't recall.
You don't know, sorry. You don't know if you placed that key fob in evidence?
No.
Okay, so does that mean you did not?
No, that means that I did not personally.
Okay, got it. Was this a document?
Mr. Chambers, can you step to the microphone, please?
Whatever it was, this key fob had the capability of starting a vehicle, fair to say.
That's fair to say, yes.
There were no other indications that the vehicle was stolen, such as tampering with the steering column or anything like that.
Oh, it's a push to start, so no.
You were just asked some questions with regards to the statement, and you're shown your police report. You did that police report, fair to say?
Yes.
And just to be clear, do you now remember what he said, or is it simply because of what you read? That's what you believe he said, because what he would have said you would put into the report.
Well, I remember because I reread my report.
Okay. So I mean, just to be clear with regards to my question, you were asked a question as to whether or not the report refreshed your recollection. You said a little. Okay, is that your answer?
I believe so, yes.
So when you say a little, what does that mean? With regards to refreshing your recollection.
That will refresh my recollection.
So are you stating that you remember what he said because now you remember what he said? Or are you stating what he said because of simply what you read off of your report?
Well, when I read my report, when I was shown it, it refreshed my memory.
Okay. I have nothing further at this.
I just have a question. I couldn't hear. I want to clarify. Trooper, you said you ran a lane, and what did you say about the VIN? I didn't hear. I just heard VIN.
So when I ran the VIN, obviously when we conduct a traffic stop, we run the license plate through SOS. And sometimes the place won't come back, so then you have to run the VIN, which is your identification number. When you run the VIN, it also runs the correct plate. And that indicated that the vehicle was stolen.
Any questions based off of that response?
No.
Mr. Sawak?
Yes, sir.
Any questions based off of my question?
No, Your Honor.
About the VIN? Trooper, you're all set.
Are they?
Your Honor, people next to call Trooper Arkin. Eli Arkin, I'm sorry.
report first, and then I'll show you. Spell your first name.
ARKN. DLIA.
Okay. So you swear to tell the truth, the whole truth, and nothing but the truth.
Yes, ma'am.
Door is right in front. Have a seat. Make sure you speak into the microphone. Every record, Mr. Fuller.
Thank you, Your Honor. Could you state your name and occupation for the record?
My name is Archon Aliyah. I'm a Michigan State Police trooper.
And how long have you been with that agency?
Coming up on 4 years.
Were you on duty on March 20th, 2023?
I was.
And were you in the area of Rose Road?
I was.
And that's in the city of Detroit, County, Hawaii?
Yes, sir.
And what were you wearing on it?
Full Michigan State Police uniform.
And the type of vehicle you were in?
Michigan State Police patrol vehicle.
Was that marked, semi-marked, marked?
It was a fully marked patrol vehicle.
What were you doing in that area on that day?
We were on general patrol.
And did you observe something at that time?
Yes, we observed a white Durango, so basically driving in circles around an overpass. It just made one round turn, higher rate of speed.
What occurred next?
The vehicle entered the freeway at high rate of speed, going westbound from Ross.
And what occurred next?
I was in the passenger seat. Trooper Owens was catching up to the vehicle, attempt a traffic stop. And then when doing so, the vehicle appeared to be exiting the freeway, what it looked like. And then as Trooper Owens kind of came up next to it, the vehicle, the Dodge Durango, had went over the, I guess, the gore or embankment, so to speak, in between the ramp and westbound 94 freeway. And then it basically jumped over that gore and then came to safety.
And what occurred next?
I observed the driver door open, and I observed the defendant exit the driver door, fall onto the ground. He then began to run up the ramp to Cadieux. I had exited the passenger side of the patrol vehicle and began running after him.
Is that gentleman in the courtroom today?
Yes, he is.
Did you give us his location and piece of clothing that he's wearing?
And he's sitting right over there, and he's wearing a like green jumpsuit.
Your Honor, let the record reflect that the trooper has identified the defendant. Were you able to catch up to the defendant?
I did run after him for a little bit, gave him at least 3 lawful orders to stop running.
Did you stop running?
He did not.
What did you do next?
I deployed my department issued taser, pointed at him, did give him a reasonable opportunity to stop running, but letting him know that he was going to be tased. He continued to keep running. That way, at that point, I deployed my taser, but it was ineffective.
What occurred next?
He seemed to fall. I don't know if it was a trip or what, but he fell. He was like on the service drive, running on the service drive, the actual roadway, came back onto where the sidewalk area was, and he fell in that area.
What occurred next?
I attempted to take him into custody by grabbing onto him. Ended up on the ground. I was on top of him. He continued to keep on trying to get up to what I suspect evade me more than he was already doing. As he was trying to get up, I kept on giving him lawful orders to stop getting up, and he refused to do so. He kept on trying to get up. At that point, I used 1 strike to his face. That deemed ineffective. I was unable to get up to him. My taser was away from my person, my body camera was away from my person. Like the way you see my microphone.
Can't you describe it for the record?
Yes, would you describe it?
Yeah, my microphone for my radio prep is right over here on my side. It was not on my side at that time due to the scuffle. It was down on my right side, but I didn't know where it was, so I couldn't pass her back up at that time. So I grabbed his hands and managed to hold his hands down with one hand, grab my prep radio, and then give the other troopers, responding troopers, my status of the situation, and then I let go of it, grabbed onto his hands and held him there. During the time, he had a satchel on him, and his hands were right next to the satchel, and I was unaware of what was in the bag. I suspected at the time it may have been a firearm, therefore I wanted to keep his hands stable, so that way he didn't remove his hands and go for that satchel.
And eventually, we were able to take him into custody.
Yes, after I was able to get to my prep radio, Trooper Owens came up the ramp and then assisted in taking the defendant into custody.
And upon taking him into custody, did you search him?
Yes, specifically his satchel was searched.
Anything else found?
Yeah.
Let me strike that. Was anything found on this person in the satchel?
Yeah, we found out like a box of Suboxone and then some hydrocodone.
And how do you know what the box?
On the box, it's actually labeled Suboxone.
Were you present, or strike that? The vehicle he was in, strike that for us.
It was a white and colored Dodge Durango.
Did you run the lien?
I did not.
At some point, did you have an opportunity to have a discussion with the owners of the vehicle?
I did.
And who is the owner of that vehicle?
No, the registered owner, would be Mr. Bradley. I can't remember his first name off the top of my head. I spoke with him, but I also spoke with his son, who advised me he was.
I am going to place an objection as to hearsay with regards to this conversation.
No, this comes in under
1101.
Thank you.
But for the owner, if it's not the owner of the vehicle, it will be hearsay, what that person said. So if the son is not the owner of the vehicle, and what he's saying, unless you have another exception.
Okay.
Or it could be authority to use if he had some control of the vehicle. I don't know, you got to establish that out.
Do you know if the owner of the vehicle had any control over the vehicle?
Who I spoke with, like I said, I spoke with the registered owner, and who the registered owner advised was the actual vehicle. So which would be the father, which was the registered owner, and the son was the actual driver of the vehicle, and that was advised to me by the registered owner.
Did either one of them give anybody permission to ride that vehicle?
No.
Did any one of them give the value of that vehicle?
Yes.
And what did they say that vehicle was?
Approximately $59,000.
Check that's the problem. Not just that, Judge, they're qualified to state.
I can't hear you.
I don't think they're I'm sorry. I don't think they're qualified to state that.
We'll start with relevance.
Sorry, Nora?
We'll start with the relevance of the value.
Under count one, it's stolen property receiving account, concealing motor vehicle. It's a felony, 5 years and or 10,000 or 2 times the value of the motor vehicle. So those towards, possible theft.
Well, what's the relevance as far as, probable cause? The penalty is not. Isn't relevant. These proceedings at least.
Okay, it says to impose a fine of 3 times the value, the defendant must admit the amount, or it must be determined by the trier of fact at trial. So I guess it would be irrelevant if they did.
Agreed. Were you present on the, for an interview with the defendant?
I don't recall if I was present.
I have nothing further.
Speak with the owner in person.
Over telephone.
Over the telephone. Did you receive, were there any written documentations that were filled out by the owner?
Not by me. I don't know what was documented by the actual agency that took the stolen vehicle report.
Okay, so you never sent or received any form that would acknowledge his ownership of this vehicle, correct?
Other than what is shown in lien, it does show like the registered owner.
But you didn't get a form from this registered owner, is that fair to say?
No, I didn't get it.
And there's nothing, you didn't receive any type of written form or give him any type of written form asking whether or not he gave permission for anybody to drive this vehicle, is that fair to say?
Yes.
So you say you spoke with him over the phone, when was this conversation had?
Yesterday. Oh, actually, this morning.
This morning?
Yes. During my last shift.
What time approximately?
I don't specifically recall. It's after midnight. I work during the night hours.
And that's fair. I mean, are we talking between 12 a.m. and 3 a.m.?
I don't specifically recall what time I made this conversation.
Fair enough. How did this conversation take place? And Judge, I just would like to say that I do want to make my objection to this testimony coming in with regards to the ownership and permission as a standing objection with regards to their say. How did this conversation take place? Did you call him or did he call you?
I attempted to call on the father, and then nobody answered the phone. I received a phone call from the son shortly after.
And how do you know that this was the son that called you?
He stated his name and date of birth.
So the person that called you back over the phone gave the name of the person who would have been the registered on the son, fair to say?
Yes.
All right. So you weren't talking to the registered owner at that time, fair to say?
Not at that time.
And you spoke with the son for how long?
I don't remember a specific amount of time, sir.
At some point in time, is it the son then passes the phone to someone who purports to be his father or the registered owner of this vehicle?
Yes.
You had no way of verifying that that was actually the owner of the vehicle, other than this person just claiming to be. Is that fair to say?
Other than the registered owner giving me his full name and date of birth, no.
Prior to this conversation, had you ever spoken to the registered owner of the vehicle?
No.
So you wouldn't know what his voice actually sounds like, correct?
It's true.
You make out a police report in regards to this conversation.
Yeah, the supplemental report.
You made a supplemental report. Did you provide that supplemental report to the prosecutor's office?
Yes.
Judge, just for the record, I do not have that report. I will acknowledge seeing an email or what appears to be a supplemental report earlier this morning, but I would ask that that report be officially sent to
You need to view right now.
No, I can go for it. Nothing further.
Redirect, Your Honor.
Any other witnesses for the people?
No, Your Honor.
No, Judge.
Your Honor, we would, given the testimony today, we are going to add count 4 being and alluding in third degree, MCL 257.602A.
Judge, I would just like to say with regards to this, I asked that specific question prior to this exam, whether or not there would ever be any charges added in this particular case, if we held this preliminary examination. The answer I was given out in the hallway was no.
The answer he was getting out in the hallway was, no, at that time I did not anticipate. But since we have it, further testimony came out, we are sure that we can add it and succeed on an additional count 4, in alluding, in third degree.
And Judge, I just would like to note as well that there's nothing surprising that came out of this testimony. And I will be making a further objection to the fleeing and alluding third degree. But I mean, just stating, Judge, I asked that question specific. And I mean, versus bad practice in my opinion.
Okay, Honor. If you have your argument, I'll let you discuss it more detail.
We also asked for a bind over on count 1, stolen property, receiving and concealing motor vehicle. Count 2, police officer assault, resisting, obstructing. And count 3, controlled substance possession and analog. And we reserve further argument.
Judge, I'll start with receiving stolen.
Yeah, Mr. Chambers, please.
I'll start with receiving and concealing stolen motor vehicle. There's nothing to indicate, Judge, with regards to the vehicle itself, that there were any identifying marks or physical indications that this vehicle was stolen to the naked eye. There's no testimony as to such. There is testimony as to defendant having that there being a key fob to this vehicle, and this key fob would have had the ability to start this vehicle. We get into the issue of ownership and whether anyone had permission to operate this vehicle. And that I could be wrong with this, maybe I missed it, but I don't believe there was testimony, even with my objection to standing, that in speaking to the son or father, I don't think there was any testimony that no particular individual or individuals did not have permission to drive this vehicle. Getting back to that, and this court would know that there is a form of possession and ownership that is typically given, filled out and signed by the registered owners of vehicles in cases like this. We don't have that in this particular case. What we have is a phone call made to the officer by an individual who purports to be the registered owner's son, who speaks to Officer Aliyah. I hope I'm pronouncing that, Trooper Aliyah. I hope I'm pronouncing that correctly. And after a certain amount of time of conversation, passes the phone to someone who purports to be the owner. I mean, there's no way of knowing who this trooper was actually speaking to at that time, Judge. I mean, so with that said, without any clear indication that this vehicle itself was stolen to an individual who was driving it, and without any testimony that, or evidence that an individual was not given permission or granted permission to operate this vehicle, I would object to receiving and concealing stolen motor vehicle. With regards to, and I'll concede for probable cause, count 2, the 2-year R&O. And for probable cause, I would concede I won't concede the count 3, the Suboxone, and there was no testing done on this, no field test. This is just something that they suspected to be Suboxone. With regards to the attempt to add a fleeing and eluding third degree, Judge, one, we don't have it here through the testimony. Officer Trooper Owens testified that he got behind the vehicle as it was entering onto the freeway. He cut his lights on and the vehicle was driving at a slow rate of speed. He also then testified that the vehicle starts to slow down as if it's coming up onto the exit ramp. I believe he named the street of the exit ramp. And that I can't necessarily, I know the area. I don't recall this. I don't know if he said Kalamazoo or where he necessarily said, but we don't have a distance, Judge, on this record as to how far Mr. Gobal went, but it would not have been very far. He was not traveling at a high rate of speed. The testimony from Trooper Aliyah was that as their scout car, which was driven by Trooper Owens, came up on and next to the vehicle that he purports to be driven by Mr. Gobal, then the vehicle veers over onto the embankment. That's an accident, and that's just all that is, Judge. And we don't have anything here that says and shows that he was trying to elude the police at that time to give rise to a third degree, Judge. And I just would repeat my issue with regards to the specific question that I asked along those lines, Judge. I mean, I'll just say, it was not presented to me, I'm not trying to make this claim, it wasn't presented to me that if you hold this exam, we're going to add charges. But there's been indications coming from higher-ups in the Wayne County Prosecutor's Office that we're really not supposed to be under any type of threat to waive examination because of the threat of adding charges. There's a reason why I asked that question. So I just don't believe the facts are here, though, Judge. I mean, there's nothing that really indicates outside of perhaps he crashed on this embankment as they're pulling up next to him on an exit ramp. Exit ramps are narrow. One lane, one car, and as Trooper Aliyah testified, they're up there next to him. They pushed him off over into that, what is it called, the gore. So the fleeing and eluding isn't there.
I'm sorry, I didn't get that fast.
The fleeing and eluding isn't there.
Thank you, Your Honor. First, with regards to the stolen property charge in count 1, the officer Trooper did in fact testify that neither one of the people that he talked to gave permission for anybody else to drive that vehicle. Furthermore, there's nothing that says that they need a form. It's their testimony under the court rule that allows them to testify to the who ownership and who has permission to drive. And well, it's not relevant in this case. But value, but as you said, that's not relevant. As to controlled substance, they found the box, it said right on the box that it was Suboxone. So, so there is, that's a controlled substance.
Mr. Maloney, I have a question for Sabree. The question was not asked whether or not he had prescriptions.
No,
So
that goes on.
how am I supposed to bind it up without facts or evidence showing that he's not supposed to be in possession?
That would be a bench order for the prior fact to decide. It was stuff. Whether or not there was substance. He had a prescription.
So at this point, I'm trying to understand whether or not it's considered a crime to have it if it wasn't established that he's not supposed to be in possession. And if you're still standing by the same answer, that's fine. I'm just letting you know
I
I'm
understand.
asking the question.
And as to the charge of fleeing or looting, third degree. First, police officer has to be in uniform, he has to be performing his lawful duties, we have that covered. And the vehicle that the driver, or the officer had, was marked as a law enforcement. It was a fully marked state trooper car. Been established that the defendant was driving a motor vehicle. That the officer ordered the defendant to stop his vehicle. Flashing lights were going. That's just, when you see the flashing lights, you are supposed to pull off to the side, and then, I mean, that's a signal that you're supposed to pull off to the side and and the defendant knew of the order. Well, the lights were flashing, so he knew of the order. On top of that, after he was off the road, the defendant ran from the car, ran over the hill, and resisted arrest. In which, for probable cause reasons, defense counsel has stipulated to. So that covers this next element, trying to flee and avoid being caught. He actually fought Officer Eli, I'm sorry. And finally, the violation resulted in a collision or an accident. Well, when he was leaving, or when he was still in the vehicle, he didn't pull over and he didn't stop until he ran off the road. So we have all the elements for fleeing and eluding of the third degree. And we ask for a bind over on all charges. And in addition,
I'll start with count one. Going through all the facts here. The people are to show the probable cause standard at first that some property was stolen. I believe that was established through lien. Trooper Owen stated that the vehicle came back and stolen. Second, that the defendant possessed that property. Testimony from both troopers shows that the defendant did possess that stolen property. Third, that the defendant knew or had reason to know or reason to believe that the property was stolen. When he possessed that vehicle. This is the one element that I believe is questionable. There's testimony from Trooper Owens that there's a key fob that he experienced with you for stolen vehicle. The trooper ran the lane and came back and stole it. And through the second trooper hearsay statement via phone that the owner fully verified by date of birth and name, full name, said that his son was the authorized driver, and then the son stated, I believe, that he drove the vehicle. I'm not sure, but the testimony is that no one else was allowed to drive the vehicle. That will be a question of fact, the trier fact. People have met the verdict, I think, fairly on that one, but they have. For count two, police officer assaulting, resisting, and obstructing, as counsel proceedings, I will still go the elements first, that the defendant resisted, opposed, who in this case, two troopers were state troopers, who gave lawful commands without the incident, turned on their lights, were fully marked, patrol vehicles, and had to chase onto the defendant, and made commands to stop running because the second trooper was going to use the tasers. Second, the defendant knew or had reason to know that the troopers were police officers or law enforcement. I believe that testimony shows through their uniforms, the cars, and the commands. Third, that the troopers gave the defendant lawful commands. Once again, I believe from testimony was there's evidence to show that it made several lawful commands through the vehicle as well as more verbally. And for count three, I don't think the people have met further proof. Wow. The defendant was in. For count three, testimony shows that the defendant was in possession of Suboxone. That is a prescription drug. In my understanding, there was no field test done. There was a box that showed that it was that drug. The question was never asked whether or not he was lawfully in possession of that or whether he had a prescription or not. And for count four, pleading and eluding, the elements show first that in this case, state trooper was in uniform. We have testimony of that. It was performing they both performed their lawful duties. Second, that the defendant was driving a motor vehicle. That's established. Third, that the officer ordered the defendant to stop his vehicle. That's been established. Fourth, the defendant knew the order. As I stated, there were troopers illuminate their lights and sirens and gave several verbal orders. Fifth, that the defendant refused to obey the order by trying to flee or avoid being caught. Excuse me. I think that's counsel's question here. I do think that the probable cause statement that's been established. The defendant did refuse to obey the order by continuing to run after orders. And I don't need to add any more elements to that. So despite the conversation that happened in the hallway and whatever promises were made, evidence was presented before me and I have to follow the law. So count three will be dismissed. Count four, pleading eluding third degree will be added as count four, count one and two will be bound over. So Since you're in custody, your arraignment of the information will be 1 week from today. Today is the 27th, so your arraignment will be May 4th at 9:00 a.m. Framework Hall.
May 4th.
May 4th, yes.
Judge, I want to address behind.
Sure.
He's currently out on a personal file of this case. I didn't know he was in custody until the doctor today. The last time we were in court, he was out on tele. Just don't want to get to it. He has a probation violation. He's on probation over to the Third Circuit Court, Judge Cusick, who currently has him on remand status. I don't know what's going to come out of that violation. But with that said, Judge, I do have concerns that technically, we're getting the technical, but it really matters to him in the potential future, is that he's not getting credit. He may not get credit for this time because it's on personal bond to you on this case. So I would ask if the court could give it to.
I changed it to 5,000, 10% cash assurance.
Okay, good. Well, and I just don't want any mistakes. It appears as though he's paid that, and that's how he bonded out. So that bond technically is paid. Can we up the bond like $100, so he's technically in custody on this case, and then something that would be made or because he didn't do anything to violate from the time that he last was in front of you. He was just picked up on a previous violation. It was actually at work when they came and got him.
Okay, but if he were to post the bond that I set, then you'll have the same issue, right?
Yeah, if he were to post up to $100, we would have that issue, but I would advise my client or his family not to post it until he's released or there's a bond posted on the case that's already in circuit.
Okay. So said $100?
Yes, sir, that's what I.
Okay, that's not a problem. So I will put $100 cash or surety.
No, Judge, you may get a call from California. I don't know if they'll call or not, but I was supposed to be there.
Oh.
Through no fault of this court.
Right, I'll let them know if they call.
Party going wrong.
No prosecutor.
I believe she just had one from her request and adjournment. I spoke to her about this.
You have a date in mind?
We do, yes. I believe it is currently May Thursday after the new charge. You're available.
May 3rd is the birthday. You know what, let me see, after your.
Okay. I mean, I believe it was May 2nd or May 3rd. She said. I don't want, to push it out more than a week, but also if the 9 or the 10th are better before.
May 3rd.
Or honestly, if you're on May 2nd,
Thank you.
Yeah.
Your Honor, may we check with the witnesses? We have several witnesses out there. Can you check? It's at 1:30, Your Honor, on Tuesday?
Okay, this is case 2356231, the people of the state of Michigan versus Benjamin Allen Vaughn, charged with 1 count of controlled substance, delivery, manufacture, cocaine, heroin, or another narcotic less than 50 grams, with an individual printed 30 minutes. That's on exam today. Appearances.
Good morning, Your Honor. Daniela Parrish on behalf of the people, PA 5495.
Good morning, Your Honor. Alexander Cho with the Neighborhood Defender Service of Detroit, 85948, appearing on behalf of Mr. Vaughn, who's present in court. Can you say your name loudly for the record? Your name loudly for the record.
Benjamin Vaughn.
Morning still.
Yeah.
Okay. Is there a discovery issue here?
Yes, Your Honor. So I received discovery yesterday. However, I attempted to download and view the videos, and there have been some difficulty with actually viewing them. I reached out to IT and probably should be resolved soon. So I requested adjournment to just handle the discovery prior to the exam.
Okay.
We've discussed this on, off the record, Your Honor. The people were ready to proceed today. All of our witnesses are here. However, I understand defense has explained to us, her need to review it. Therefore, we will not object. We're just trying to pick a time that works not only for the APA prep the case, but also our officers that are here. I know off the record, we had indicated possibly Tuesday. People do not object to that. We just prefer if it could be in the morning because our officers have difficulties in the afternoon doing the case. Maybe later in the morning, just preferably in the morning, they indicated.
I would not be available this coming Tuesday until the afternoon. I would be available on May 9th.
One moment. Your Honor, we don't have times at noon, do we? Because that's the lunch hour.
No.
Okay. Your Honor, unfortunately, we don't have the schedule on the night of the 8 days, but see if we can double check to see if it'll be here on that day. Again, we're just trying trying to avoid wasting more time and passing it off since it was already prepped by one AP, passing it off to a different AP. So we just, our only request is having it on the day that that AP will be. And then as far as the officers, so that they can all be here.
What about 8:30?
Your Honor, I had hearings, I believe I had like 5 hearings that morning, the last meeting.
Hearing council.
I had around 5 hearings that morning, starting at 8:30 through 11. It would.
We're just trying to get a new day. I just want everyone in the room, so everyone's here today, but I want you all to be able to appear for the next court date.
Your Honor, it's fine. If he's not in here, I'll take it over. We can put it for the night if they do a morning. That way these officers don't have to come in the afternoon. If we have a morning at the night. Instead of holding up the court any further, I know we have another case.
Okay. So what's the, May 9th, what's the issue?
No, there's no issue. I'm saying if we, as long as it is, we can do morning. I know that you initially were gonna put the second, but it's afternoon and it's difficult for all the officers to get here in the afternoon.
9 o'clock? May 9th?
Thank you, Your Honor.
May 9th at 9 o'clock, everybody?
Yes.
I have Zoom already at 9 o'clock, so I'll probably do both.
Okay.
If possible.
Say that again?
I have Zoom at 9 o'clock. At 1 o'clock.
When you say Zoom.
Zoom court, so I will have both.
From here?
Right, yeah, that's one thing.
Yeah, as long as you're here in person. Okay. And it's as long as you can Zoom it in. Your Honor, can we make it a tad bit later? I just don't want it to be held up. One of the officers will be at circuit court at 8:30, and you know that usually they end up going a little over.
11 o'clock?
11?
Yes.
All right, thank you, Your Honor. Sorry about that. Oh, wait. Thank you, Your Honor.
What we were doing? Okay, we're on the record. This is people of the state of Michigan versus Charles Lee Thomas, 2356122. Mr. Thomas is charged with 1 count of robbery armed statutory exam today. Appearances?
Edwards, Walker, CR438.
May it please the court, neighborhood defender service of Detroit by Jeffrey Connecting 4800 on behalf of Mr. Thomas.
And good morning, Your Honor. Good morning to your staff. Neighborhood Defender Services by Ken Reagan, P82125 on behalf of Mr. Charles Thomas, who stands behind us. Mr. Thomas, can you state your name for the record, please?
Charles Lee Thomas.
Morning. Is everyone ready to proceed?
No, Your Honor, we've unfortunately felt briefed. Yes.
Move to dismiss, Your Honor.
11:39. Exam was set for 10:30. So if the witness is late, I think that witness will be here by now. I am going to dismiss without prejudice.
Thank you, Judge.
I have one.
May I approach, Your Honor?
So we can wait outside the board for your turn.
I was gonna sign,
Oh, I was like, what are you talking about?
Sorry. Fair enough. No, I'll get the dismissal, get it in the file, you can tell him I'll give him a copy.
All right.
Yeah, look at that head check, you can change.
3. Wrong file. That was the wrong page.
I like, I'm sorry, that's my, I like.
Charles Thomas.
I have Willis, Andre. That's not. Okay. My hair. Okay, I'm sorry.
I don't know if I believe you. I don't believe you.
Okay.
Calling
case 2356018, the people of the state of Michigan versus Andre Willis. Willis is charged with 1 count of weapons carrying concealed, set for a preliminary examination. Appearances?
Ellis here on behalf of the people, P85495.
Good morning, Your Honor. May it please the court, Matthew Dupree, P80132, attorney for defendant. State your name, please, sir. Andre Willis.
Good morning, still. Is everyone ready to proceed?
Your Honor, apologies, the people are unable to proceed at this time, are necessary witnesses still to appear.
Judge, we would move to dismiss.
Okay, I will dismiss without prejudice, as the people are not ready to move forward.
Thank you, Your Honor.
You're welcome. Look confused, sir. Mr. Willis, you know what just happened?
Yes, yes,
Okay.
I do. Thank you, thank you, Your Honor.
You're welcome. Have a good one. Plaintiff for People of the State of Michigan versus Imani Armand Harris.
Evan Zawaki, P54828, on behalf of the people.
Good morning, Judge Hannah Barron, P85265, representing Mr. Harris.
2355971. Mr. Harris is charged with one count of weapons carrying concealed. Mr. Harris, can you state your full name for the record, please?
Imani Armand Harris.
And is everyone ready to proceed?
Yes, Your Honor.
Yes, Judge.
Okay. If there's anyone on YouTube or Zoom who may be a potential witness, now's your time to log off. For the record, there's no one in this program other than staff, attorneys, and Mr. Harris. With that, you call your first witness.
People call Officer Jordan Thornton. Your Honor.
Okay, thank you.
You swear to tell the truth, the whole truth, and nothing but the truth.
Yes, ma'am.
Yours in the front, make sure you speak up. Be ready to select.
Thank you, Your Honor. Officer, can you state your name for the record, please, and your occupation?
I'm a police officer, Jordan Thornton,
And what agency are you with?
the Detroit Police Department,
How long have you been with them?
3 years.
And were you on duty March 14th of 2023?
Yes, sir.
And were you in the area of Vaughn and West Warren?
Yes, sir.
Is that in the city of Detroit and County of Warren?
Yes, it is.
Now, what were you there?
I was patrolling the area.
And did you observe something occur in that area?
Yes, I did.
And what was that?
It was 2 males jaywalking across the street.
And is one of those gentlemen here?
Yes, sir.
And you point to them and identify his clothing?
It's wearing a black hoodie.
Let the record reflect that the officer has identified the defendant. What happened after you observed the jaywalking?
Yes, I observed him jaywalking, almost get hit by a vehicle. And I approached the 2 gentlemen. And as we approached them in the vehicle, I observed a shape of a firearm in his pocket.
Before we go further, what were you dressed in?
In my uniform.
And were you in the vehicle or on foot?
In a vehicle.
Was that vehicle marked?
Yes, it's semi-marked.
We say uniform, what do you mean?
I'm in my standing uniform right now.
You describe it for the record.
It's green pants, black shirt, black vest, Detroit logos. Detroit Police logos.
And when you say semi-marked vehicle, could you describe that?
Black vehicle with Detroit Police on the side.
Let's back up. Can you say you observed something in a pocket? Whose pocket?
Other defendant.
And could you describe what you saw?
I saw an outline of a firearm in his front pocket.
And
Pocket was extremely heavy. Sagging down on one side.
and what did you do next?
I approached the 2 males. I asked them, are they carrying a firearm? Does anyone of them have a firearm?
And then,
And they stated no.
at any time did the defendant provide you the CPL license?
No, sir.
What did you do next?
After I asked him to have a fireman stay there, no, I asked him, could I pat them down? And he said yes.
And
At that time, I recovered the firearm, a loaded firearm.
what type of weapon was that?
I believe it was a Taurus firearm, black and colored.
Was it loaded?
It was loaded and stolen, yes, sir.
And what did you do next?
I placed the firearm inside my vehicle, replacing both of the handles.
And did you do any further investigation?
Yes, my partners did, most of that part, but yeah, we ran them for CPL and it did
Objection
not
to
happen.
anything that isn't this officer's own observation. I'm objecting to anything that isn't this officer's own observation.
Response.
Did you observe your partner run the lean?
Yes, sir, well, he did inform me that personally he didn't have a seat. That's why he placed him to the back of the scalper.
Do you know the age of the defendant?
Yes, 18.
What happened to the weapon after?
I was placed on evidence,
Defendant?
conveyed to the DEC.
I don't have anything else.
I have one question, I'm not sure if I heard it. You said you patted him down after you had permission, correct?
Yes, ma'am.
Where did you pat him down?
In his pockets, his waistband.
Any questions based off of that?
No, Your Honor.
Cross.
Good afternoon. So officer, when you made the observations that you're testifying about, you were driving on Warren Avenue, is that right?
Yes, ma'am.
And that's where you were initially driving down Warren Avenue, correct? And what direction were you initially driving down?
Traveling east.
Say that again?
I'm traveling eastbound.
Okay. And you testified that you observed two people jaywalk, is that right?
Yes, ma'am.
And were the people in front of your police vehicle or behind your police vehicle?
They were in front.
In front of your police vehicle?
Yes, ma'am.
And so officer, it's correct that you were initially driving down Warren Avenue, then you turned back around, and then you turned back around once again, is that right?
Yes, ma'am.
Okay, and so, at what point during those turns did you make your observations of the two men?
When I approached them.
Okay, at what point did you make your observations about the jaywalking of the two men?
When I first observed them.
Okay, so when you were first initially traveling east on Warren Avenue, is that right?
Yes, ma'am.
Before you made any turns, is that right?
Yes.
Okay. And you testified that they were jaywalking again, correct?
Yes, ma'am.
And that means that they were crossing the street and they didn't use a crosswalk, is that right? And that's all you mean by jaywalking, correct? Okay. And did you make any observation about if there were any crosswalks in the area?
Yes, ma'am.
Okay, how far was the closest crosswalk?
Bond is one street west of Evergreen. There's one street, so like.
Okay, so your testimony is that one street down there was a crosswalk, is that right?
Yes.
Okay. And so after this whole interaction, you issued a civil infraction to Mr. Kimani, is that right?
I did.
Okay. Did your partner that you observed? Okay, so you're unaware of whether Mr. Harris was given any civil infraction for allegedly jaywalking?
I'm not aware.
Okay. And you testified also that you watched the two men almost get hit by a vehicle, is that right?
Yes.
And
again, this was before you made any turns in your vehicle, correct?
Yes.
Okay. Just gonna pull up. Judge, could I connect to the Zoom to, okay. Sorry, what's the meeting ID in here?
CR438.
So officer, I just wanted to see if they're gonna. I was just seeing if there's any echo. Okay. Officer, I just pulled up some footage. Do you recognize this at all?
Not really.
Okay. Okay, I'll play a little further. Okay, do you recognize what I played? Okay. And do you recognize it as dash camera footage from the day of the incident that you're speaking about? Okay. And do you recognize the two people that we can see on the screen right now as the people that you're describing?
Yes.
Okay, one of whom you identified as Mr. Harris, is that right?
Yes.
Okay. And so officer, when you testify that the two were jaywalking, because you testified that they crossed the street without a crosswalk, are you referring to down a side street or down the major street?
When they cross the Warren.
Okay,
From the south, from the north to the south side.
okay, so the two-way street, is that right?
I don't know what you mean by that, but they cross the other side of Warren, the other side, from the south side to the north side.
A street with two-way traffic on it, correct?
Yes.
Okay, so I'm gonna go back to the beginning of this. So officer, right here, you're driving east on Warren, is that correct?
Yes.
And the two figures on the left of this screen, those are the two people that you're testifying about, correct?
Yes.
And your vehicle passes them, is that right? And at no point before your vehicle passed them did the two cross the street, is that right?
Well, they were crossing the street driving.
Okay, so from what we've seen, at no point when you were behind them, when the two of them were in front of you, did they cross the street, is that right?
Yep.
Okay, okay. And so officer, you testified that a car almost hit them, is that right?
Yes,
Okay, and what direction was that vehicle going?
I don't recall.
Okay,
That's what you are.
okay, that's what drew your attention, that a vehicle almost hit them, is that right?
It was the horn. If I can recall correctly, it was the horn.
Okay, and so officer, playing further on this dash camera footage. There are no vehicles coming westbound down the street, is that right?
Yes.
That's correct?
Yeah.
Okay. And so, officer, did you see any vehicles almost hit them in that dash camera footage?
Oh, no.
Okay. And so, officer, the area on the street where you saw the two of them cross, there was actually a yellow sign right by where they crossed, is that right?
Okay.
Okay, would it refresh your recollection to watch this again? Okay. So officer, again, this is the beginning of your dash camera footage, and right on the left side of the street, those are the two people you're testifying about, correct?
Yes, sir.
And right across the street from them, there is a yellow sign, is that right?
Yes.
And that yellow sign has two pedestrians on it, is that right?
Yes.
And there's an arrow pointing towards the street, is that right?
Yes, sir.
Okay, and that's right where the two of them crossed, is that right?
Yes, sir.
Okay. And so, officer, after you observed the two men cross the street, you turned on your vehicle lights, is that right?
I didn't know.
Okay. Okay, but you observed your partner turn on the vehicle lights, is that right?
I don't recall.
Okay. Okay, but you stopped your vehicle right by the two men, is that right? And you initiated the stop, is that right? And that was all based on them crossing the street, correct? The manner in which they crossed the street.
And almost get hit by a car.
And you then instructed the two of them to walk towards you, correct?
Yes, sir.
And you instructed them to stand in front of your car, is that right?
Yes, sir.
And they did comply with the order, correct?
Yes.
They walked towards your car, they stood by the car, is that right?
Yes.
And you asked them to take their hands out of their pockets, is that right?
Yes.
And they did,
Yes, sir.
correct? And they put their hands up, is that right?
I don't recall that.
Okay, you just recall them complying with all the orders, is that
Absolutely.
right? And was that around the time that you noticed a bulge in one of their pockets, in Mr. Harris's pocket?
I don't recall when I noticed it, but it was at the time when giving them the orders and command.
Okay. So it was after you stopped them, correct?
No. When we approached them, you know, because I noticed that they were just children or juveniles. And, you know, so that's why we turned around and we approached them. That's when I noticed.
Okay. And so officer, you testified that you don't recall whether or not the lights of your vehicle went on, correct? Okay. And would it refresh your recollection to watch a little bit of this? So officer, does it appear that the lights of the vehicle went on?
Yes, ma'am.
Okay, so the lights of your vehicle went on before you exited the vehicle, correct? And you first noticed a bulge after you exited the vehicle, correct?
Correct.
Okay. And you testified that the bulge that you saw was the outline of a firearm, is that right?
Yes.
And where was that bulge?
I don't recall, one of his front pockets, I don't recall right or left.
Okay, and so when you say front pockets, of what clothing
Of
item?
his jacket.
Okay. All right, and so I'm gonna play.
Second video,
Yes, and I'll play a little more and then ask the officer if he recognizes it.
are you entering the first one that you played?
Yes, I would need to enter that into evidence.
As proposed, is it A?
No objection.
Thank you. Thank you.
Sorry, Judge. It'll be entered, yes. As defense procedure A. That's the dash camera.
Yes.
Of course. Yeah.
And officer, do you recognize this or should I continue playing a little bit?
Yes, all right.
Okay. And do you recognize it as your body camera footage from the night of the incident you're testifying about?
Yes.
Okay. I'm sorry. I'm just gonna play it without sound for the purposes of this. So officer, is one of these two men the one that you identified as Mr. Harris? And would that be the person closer to the screen?
I don't, can't tell right now.
Okay. So you can't tell either from the jackets that you see on screen right now?
Honestly, man, it look like the exact same jacket.
Okay. You can't tell from any bulges in the jackets which one is which?
No.
Okay. And at this point, can you tell which one is which?
Yes.
Okay, and is the one closer to the screen Mr. Kimani Harris?
Yes.
And this is the jacket that you've described seeing a bulge in. And do you see it in this image?
No.
Okay. And I would just move to admit this as, I think that was exhibit A. So as exhibit B.
Any objection?
No objections, I'm going to see the rest of it.
If that's what the court wants.
That's the people's objection. This video says 37 minutes. I don't know if all those be necessary. But,
Just a few, not the whole 37.
if you want it all played, then that's your right to have it played. It's made a minute.
Well, I just want to see a little bit more of the video.
Okay, that's fine. I
In
need
the
to.
whole 37 minutes.
Okay, and is it okay if I continue to play it on mute or do you want the sound on?
Yeah. Your Honor, if people are satisfied, then no further objection.
Okay, it'll be a minute as Defense Exhibit B.
And so officer, you testified that, after you asked Mr. Harris to come towards the car, after you told him to put his hands out of his pockets, you then asked him if he had any weapons on. Is that right?
Yes.
Okay. And he said no, correct? And then you testified that you asked Mr. Harris if you could pat him down. Is that right?
Yes.
But in fact, you actually asked Mr. Harris, mind if I check? Is that right?
I know that I probably didn't use the exact verbiage, but I asked him, could I pat him?
Okay. And would it refresh your recollection if I played this with sound?
That's fine.
Okay.
Sure. Take your hands out your pockets for me. Don't stop walking. Yeah. What's going on, man?
You played from the beginning.
Yeah, sure.
Take your hands out your pockets for me, boss. Don't stop walking. Yeah. What's going on, man? We just in front of my car. We just really don't be here. We walking to the store. Okay, in front of my car. You want the weapons on you like that? No. Mind if I check? No. Face the car for me.
Is this gonna, okay, sometimes my voice comes over. Okay, so officer, is it correct that you said to Mr. Harris, mind if I check?
Yes, sir.
And his response was no, is that right? And he shook his head when he said no, is that right?
I didn't see that.
Okay. And so officer, you testified that you then patted him down, correct? And you testified that you did that by patting his pockets, is that right?
Yes.
Is that the first place that you patted his pockets?
Yes, ma'am, but that's where I saw it.
Okay. Nothing further, thank you.
Officer, your dash cam, it points in one direction, right, in your vehicle.
Yes, sir.
So, say you're sitting in your car right now, and you're facing this way, you can catch me, right?
Yes, sir.
But, your head rotates 180 degrees, correct?
Yes, sir.
So while the dash cam would be looking at me, you can turn your head and look at the judge, correct?
Yes, sir.
Where is your body cam?
On my chest.
Did you point? Let the record reflect that the officers pointed to the sternum area. And the same thing goes with that. Your head is more flexible than that body cam, correct?
Yes.
Nothing further.
Amen.
Any other witnesses?
Nothing from the people, Your Honor.
Any defense witnesses?
Yeah, the people asked that the defendant be bound over on count one, weapons carrying and concealed. Reserve argument.
Judge, Mr. Harris was, his Fourth Amendment rights were violated during this stop. He was initially illegally stopped when Officer Thornton and his partners stopped their vehicle based only on Mr. Harris's alleged jaywalking across the street. Judge, we haven't received anything from the people as to what statute exactly Mr. Harris is alleged to have violated by crossing the street. The officer can testify as to what statute Mr. Harris allegedly violated by crossing the street. He hadn't issued any ordinance to Mr. Harris. He wasn't aware of any civil infractions that were issued to Mr. Harris. But he did testify that he was almost hit by a car. And we saw on the dash camera footage that this was extremely incredible. The officer testified first that he made these observations when Mr. Harris and the other person Mr. Harris was with were in front of the vehicle. When we watch the dash camera footage, they don't cross the street in front of the vehicle. Nothing happens when the vehicle is facing these two young men. And certainly we don't see anyone get almost hit by a car while crossing the street. We see one car turn into another street and not even go down that path. So it's extremely incredible what the officer testified to, that the two young men almost got hit by a car. And even that they were jaywalking. We also saw from the dash camera footage, and the officer testified that there was a sign pointing to directly where the two young men allegedly crossed the street. And that sign indicated that people could cross there. So we haven't heard about any violation. What the sign means? Judge, I'm not certain what that sign means, but I'm certain what the sign shows, which is two pedestrians with an arrow pointing towards the street. And Judge, the officers did stop Mr. Harris and his friend at that point. They turned on their lights. They called them towards them, and issued commands to them, which they followed. And at that point, the officer alleges that he saw a bulge. This is also incredible, Judge. We saw the body camera footage. There's no bulge on Mr. Harris's person. But even if there were a bulge, Judge, there was no testimony from the officer that he knew anything about the two men's CPL status or anything that would make carrying a gun, if there even were a bulge, if there even were an outline of a gun, which again, we can't see, nothing that would make that illegal. So the bulge certainly doesn't give the officers any other reason to search Mr. Harris. And then from there, Judge, the officer asked Mr. Harris, "Mind if I search you?" And Mr. Harris shakes his head and says no. Judge, I don't think that this is unambiguous. This is ambiguous. And anecdotally, because I don't think that this has any precedent, but anecdotally, I've seen officers ask that question and the person respond yes. And that has been taken as consent as well. It appears to be some kind of trick question, really, that officers ask because there's no correct answer. There's no answer that the officers will take as not having given them consent. Mr. Harris shook his head and said no. This was not unambiguously giving the officers consent to search the person.
Yeah, this is a probable cause, and a lot of what defense counsel has brought up is a question of fact or the trier of fact. As far as the crossing the street, there doesn't have, all it has to be is a suspicion of something. And all the crossing of the street at what was thought to be jaywalking, it was what brought these gentlemen, the defendant, to the officer's attention. The fact that there's no car on the dash cam, as I indicated, that points in one direction. The officer said testified that he saw a car that almost hit him, and he very well could have, and then not be picked up on the dash cam. So the reason that it's very reasonable that they would have put young kids juveniles at that time. It's dark, and they almost got hit by a car. I will also note that the sign is on the complete opposite side of the street of where the defendant was walking. So it's like, it's officers looking at the defendant, he just happened to not see the pedestrian sign. And therefore he thought they were jaywalking. He had enough suspicion to check, to investigate further. The officer didn't testify that he did not see, or that he did see the bulge, the gun bulge in Penn's jacket before he got out of the vehicle. So the fact that the video doesn't necessarily show him seeing the bulge, again, he's in the car. His dash camera obviously didn't pick that up. These are all questions of fact. When he stopped and asked if he could search, and began to search, the defendant, we get nothing from the defendant even asking what he's doing. So it's obviously the defendant knew when the officer, can I check it, knew what he was talking about. They wanted to check his person. And when he did, he found the gun. This is a probable cause. Everything that the defense counsel has pointed out, if nothing else, is a question of fact. And people have shown enough probable cause to find the weapons carried at concealed charge. Thank you.
I do think the people have been to be a question of fact, the trial fact. This starts to sound like a jaywalking hearing versus the CCW. The dash cam, as we all know, is limited. The officer's testimony is that he observed the defendant cross the street, where there was a crosswalk, as he called it, jaywalking. It's clear on the video that you see, or that you can come to the reasonable conclusion without seeing the two individuals across the street, that they were on one side of the street on the video, and when they appeared again on the dash cam, they were across the board on the other side. Every other possible reasons or possible means to get across the street, yes, but I don't think they would have been reasonable. So based off of that, the officers, or officer testified, Officer Jordan Thornton, made a U-turn and began to ask questions and investigate, in which he saw what he believed to be a shapen firearm in a pocket, the jacket sagging down. The question of fact that will probably be an issue as to whether or not there was consent. The words on the video were "minded by check," and the defendant said no. English language. That sounds pretty clear. The shaking of the head, I'm not sure if it was shaking up and down or left and right. That will be for the trial fact. After the stop and checking the defendant's pocket, the handgun was found. Then 18 years old, he's not allowed to carry a weapon, let alone a concealed weapon without a CPL. So for those reasons, I will have to bond over for an arraignment on the information. It'll be 2 weeks from today, Mr. Harris, since you are out of custody. Today is the 27th, so May 11th at 9:00 a.m. Frank Murphy, Hall of Justice. Anything else for you, department?